5, 4, 3, 2, 1.
This Honorable Court of Criminal Appeals of Tennessee is now in session.
Good afternoon. Welcome to the final case on the October docket for the Court of Criminal Appeals in the Eastern Section. The panel today, Judge Camille McMullen from Memphis, Judge Jill Barty Ayers from Clarksville. I'm Kelly Thomas from Maryville. Again, thank you to Jim Hibner and Nick Morgan for all their assistance, even though apparently we have a ghost in the system somewhere and can't see what the problem is. But for them, we certainly would be having problems. So thank you so much. 20 minutes aside, both of you have argued before already today, and General Redding, this is your third one, I think. So do you want to keep some time for rebuttal, Mr. Hedrick?
Yes, please. If the court will grant me 2 minutes rebuttal time.
2 minutes. All right. If you will call the case, please.
State of Tennessee versus Randall Tate.
Thank you. Your Honor, Josh Hedrick here for the appellant Randall Tate, and may it please the court, Mr. Tate's convictions in this matter should be reversed for 3 reasons. First, because the evidence is insufficient. Second, because the trial court erred in admitting text messages regarding prior drug sales, contrary to Rule 404 and Rule 402 about relevant evidence. And finally, because the trial court erred in denying a Ferguson motion relating to a video recording from the jail. The short version of the facts in this case were that Mr. Tate was arrested after a traffic stop. He was taken to the Knox County jail, the Knox County detention facility, where he was booked in, taken to a changing room to change his clothes into his jail uniform. And after changing his clothes, a bag was discovered that contained some narcotics, and that led to the felony possession charge. We posit that the evidence was insufficient as a matter of law to support the conviction for possession of a controlled substance for resale, because at the time that Mr. Tate entered the facility, he had been searched twice and patted down twice. So 4 separate goings over of his person, as it were. These searches were careful enough that they uncovered a single loose pill in his pocket. That's volume 7 at page 37 in the record. Then he's taken into this changing booth, which was described as being similar to a stall in a public restroom with a door and a bench in which they could change their clothes into their inmate uniform. Now, the deputy, Torres, who was the officer in charge of watching this process and monitoring this process, testified that he did not see anything on the bench. He was not specific about the rest of the booth, as it were, and that he did not search the booth before Mr. Tate entered it. Now, this action, his arrest, his changing clothes, happened 2 hours into Deputy Torres's shift. So for 2 hours, there had been people presumably coming through the detention facility, through the booth, changing clothes, taking their clothes off, putting their inmate clothes on. And there is no way to demonstrate in this record, from this proof, how many people came through in that time, whether those people were searched carefully, and if one of those people may have deposited this bag that was found. I think it's particularly important, given that Mr. Tate obviously denied ownership of the bag when it was found, but he was searched twice on a full-on search and 2 pat-downs, and none of those uncovered this Crown Royal bag full of drugs. Now, as we'll see later in the Ferguson argument, the state relied on the presence of the drugs being where Mr. Tate was for the conclusion that he must have been in possession of them. And that is, the deputy opened the door and there was Mr. Tate and there was the bag, and therefore it must have been his because it couldn't have come from anyone else. But we can't actually say that, partly because of the Ferguson issue deprives us of the ability to say that, but also because we've got 2 hours worth of bookings that we can't account for. We combine that with the fact that he was carefully searched repeatedly without any discovery of the narcotics, and we conclude that the evidence is insufficient as a matter of law. On the second point, we suggest that it was error to admit the prior drug sale text messages. There were some text messages found in a phone in Mr. Tate's possession. Those messages were relating to meeting to exchange some narcotics, some drugs, some pills, and they were admitted over objection on the state's argument that they were admissible to prove intent and therefore permitted under Rule 404B. But Rule 404B2 allows proof of intent in order to resolve a material issue. We suggest to the court that there is no material issue of intent here. Now that it's interesting that it's not couched as an element of the offense, but rather a material issue. And I'd suggest to the court that we should consider material issue the same way we think of materiality for the purpose of determining relevance, since relevance and 404 are in the same section of our evidentiary rules. And that is that before it can be material, there must be a controversy. There must be some controversy to which it addresses itself. In this case, the intent was not in controversy. There was no claim and no argument that this was a simple possession. There was no assertion that the intent was something other than for distribution or sale. The only issue, that is, the only controversy, was whether this bag was in Mr. Tate's possession. Now,
Well, excuse me just a second.
Yes, sir.
Whether anybody is questioning the intent to sell or deliver, the state still has to prove it to the jury's satisfaction, correct?
It does, Your Honor, and there are other options available, non-propensity risking options. I'm not entirely sure how to phrase that, but what I'm getting at is
things that don't implicate a danger of unfair prejudice.
That's exactly what I mean. That is, we can talk about the amount of drugs involved. The court can see from the record that certainly more than a person would be expected to use at one sitting, as it were. That doesn't involve the amount can support an inference of weight. The way in which it's packaged can support an inference of weight. Just as I would suggest the court the simple number of drugs involved, the amount of drugs involved supports that without running the risk of the propensity angle being taken by the jury.
Okay.
And in this case, there was no claim to the jury. The only question for the jury that was put to it, and the court can see plainly from the transcript, the question put to the jury was simple and plain, and the defense made it plain. You have to decide whether this is his bag or not. That's all we're asking you to do, jury. Just decide if this is his bag or not. So we suggest that the state in its brief makes issue of the fact that this was something that had to be put forward, that the state was entitled to put it forward. And I suggest to the court that the state is only entitled to put it forward to the extent that it is in issue, that it is a controversy that needs resolving. And in this case, it is not a controversy that needs resolving. And therefore, this evidence does not resolve a material issue. If it doesn't resolve a material issue, it cannot be relevant under 402, and it can't meet the test under the definition, rather, under 404B2, which depends on materiality. And for that reason, Your Honor, we suggest that it was error to admit those text messages. And because of the nature of those text messages, because those text messages were dealing with drug transactions in a drug possession case, that the risk of the jury taking that for a propensity purpose is very high, and the prejudice is very high, and it is too high to have been harmless error. And for that reason, we suggest to the court, and when I say too high to be harmless error, we have to look at it in terms of what I've already mentioned about the sufficiency of the evidence. That this is not a case where there is overwhelming proof of his possession of these drugs. Had they been taken directly from his pocket at the scene of the traffic stop, for example, I think that there certainly could be a harmless error argument, but this is not that case. Finally, if Your Honors, please, It was error to deny the Ferguson motion in this case. This room that we've been talking about, this changing room in the detention facility, was described to us by the witnesses at trial as being the old shower room. It apparently, years ago, when inmates were brought in, they were taken to shower, and these were the shower stalls that were used for that purpose, that they later fitted doors to them, and they became changing rooms. They put in a bench and they put in doors, and there are 3 changing rooms. There appears in the record a photograph of the room to give the court an idea of the layout that we're talking about. And we went through this in some detail, the motions and trial below. And the issue in the Ferguson motion is the defense's ability to adequately cross-examine the state's witnesses. The state, in its brief before this court, has suggested that the argument raised on appeal is different than the argument advanced at the trial court. I take this opportunity to suggest to the court that that's simply not so. The argument in the brief is a specific statement of what cross-examination was deprived of at the trial court. That is, at trial, the complaint was this has deprived us of the ability to adequately cross-examine the witnesses. And on appeal, we've attempted to set out specifically what that cross-examination would look like. Because this video deprives us of the ability to answer the questions which we began with at the start of this argument. That is, the questions of who were the other people in and out, how many people were in and out, what kind of searching or checking was conducted of these booths in between the 2 hours worth of prior arrests before Mr. Tate got there. And I say 2 hours because Deputy Torres testified that the booths were searched at the beginning of his shift, and that he had been on shift for about 2 hours when Mr. Tate came in to be booked into the facility. And so we've got 2 hours since the last time they were searched. The video could assist the defense in questioning Deputy Torres about what happened in those 2 hours. We could see how carefully people are checking the booths. We could see how many people are in and out of the booth, and what those people are taking in with them or leaving with them. It is helpful and necessary for cross-examination. And that's particularly important because the state's case for possession depends entirely on the fact that Mr. Tate was near the drugs when the drugs were found. The state's argument is that Deputy Torres opened the door and there was Mr. Tate and there was a bag, and therefore it must be his because he was the only person there. The problem with that logic may hold true if it were applied to Mr. Tate in his car. They open the car door and Mr. Tate's the only occupant and there's a bag. Well, it probably is his. Or in Mr. Tate's living room, they open the door to the house and there's Mr. Tate. That makes sense. But this is a room that by definition holds people coming into the jail from arrest in a transient fashion. They're in and out and in and out and in and out. And we cannot adequately cross-examine Deputy Torres in the absence of this video. We cannot present that to the jury in the absence of this video. And that video, the value of that video should have been immediately apparent to the government, because the government knew that its argument was based upon Mr. Tate's presence where the drugs were found. And it should have been immediately apparent to the government that the next logical question is, all right, who else was present when the drugs were found? And the answer to that question lies within the video. In its brief, the government views exculpatory evidence too narrowly and suggests that it's not exculpatory because the video did not show someone actively carrying in a bag of drugs. Here's my bag of drugs, and I'm sitting them in this room. And that's too narrow a view, respectfully. That the view this court should adopt of exculpatory is similar to our definition in Johnson, right? Our Tennessee version of Brady, that it is material to the defense and that it is material to cross-examination in this case. In this case, the video was in the exclusive control of the government. Its evidentiary value should have been immediately apparent to the government. It should have been preserved, and its failure to be preserved deprived Mr. Tate of a fair trial because it deprived him of necessary evidence to mount his defense in this case. And for that reason, along with the others, Mr. Tate's conviction should be reversed. Thank you, Your Honors.
Thank you. General Redding.
May it please the court, Catherine Redding on behalf of the state. I'd like to apologize to the court for my technical issues this afternoon. But moving on to the defendant's first claim, the evidence is sufficient to sustain his drug convictions. Viewed in the light most favorable to the state, the evidence is sufficient to show that the defendant possessed the heroin and Xanax found at the detention facility. The K-9 unit, which searched the defendant's vehicle, was not alerted to train on Xanax, but nevertheless alerted on the defendant's car for the odor of narcotics. Although there were no narcotics in the defendant's car, the dog could alert on odors even after the narcotics were no longer present. When the defendant was searched incident to arrest, officers found one Xanax pill in his pocket. The defendant was transported to the detention facility and taken to a changing stall that had been searched 2 hours before and found to be empty. Before the defendant entered the stall, Deputy Torres looked inside. Deputy Torres testified that he did not see anything inside the stall and specifically stated that the bench was empty. But after the defendant changed out of his street clothes, Deputy Torres observed a green cloth Crown Royal bag on the bench of the changing stall, and that bag was pressed up against the defendant's recently shed clothing. This is more than just a situation of the defendant being in the same room as the bag of drugs. The bag was literally touching the defendant's clothing. And that Crown Royal bag contained 13 Xanax pills that were consistent in appearance to the single pill found in the defendant's pocket earlier, as well as 2 baggies containing 3.68 grams of heroin. A jury could find that the defendant possessed the heroin and Xanax found in the changing stall. The jury heard about the various searches of the defendant's person, and it heard Deputy Torres testify that the defendant had immediately disclaimed ownership of the Crown Royal bag once Deputy Torres saw it laying up against his clothing. But the jury rejected the defendant's suggestion that someone else had left the bag of drugs in the changing stall, as was its prerogative. And it's the province of the jury to assess the evidence and the credibility of the witnesses, and this court does not revisit the jury's determinations on these kinds of issues. As a result, the evidence is insufficient to support the defendant's convictions. As to the defendant's second claim, the trial court acted within its discretion in admitting the defendant's text messages about prior drug sale into evidence. First, the trial court complied with the procedural requirements of Rule 404B, so its decision is reviewed for abuse of discretion. And the record supports the trial court's decision to admit the messages into evidence. The state did not introduce these text messages to prove that the defendant possessed the heroin and Xanax in conformity with a character trait. Rather, the messages were offered to prove the defendant's intent, that he possessed these drugs with the intent to sell or distribute. And this court has recently and repeatedly noted that evidence of prior drug sales is probative of defendant's knowledge and intent to possess drugs for resale. The messages were logically connected to the charged offenses because the messages were exchanged days prior to the offense and discussed the sale and delivery of both the drugs that served the basis of the defendant's charges. And that logical connection between the prior bad acts and the charged offenses distinguishes this case from State v. Hughes, I believe is how it's pronounced. And as the defendant's claim that intent was not a material issue at trial, the defendant's not entitled to relief. The defendant's decision to center his defense on the essential element of possession did not preclude the state from offering proof of intent. The state had to prove that the defendant acted with specific intent, thus intent was a material issue. And there is a distinction between a material issue and a contested issue. And there are case law from the United States Supreme Court, the Sixth Circuit, from this court, saying that the state's burden to prove every element of the offense is not relieved by a tactical decision by the defendant not to contest an essential element of the offense. And so just because the defendant chose to focus on the possession element of the offense doesn't mean that the state was prohibited from putting on its proof. The state still had to prove the specific intent of the defendant. And as to the defendant's claim that this was not a contested issue, the record shows that not only was intent a material issue, it was also a contested issue. The defendant did not concede or offer to concede this element. Had the defendant done that, this would be a different case. But the defendant didn't do that. He didn't concede the element. In fact, the defendant challenged the state's proof of intent on cross-examination before the state admitted the text messages into evidence. So for those reasons, intent was a material issue. It was also a contested issue, and the trial court acted within its discretion when it admitted the text messages into evidence. As to the defendant's final claim, the defendant has waived his Ferguson claim by pursuing a new theory for relief on appeal. In the trial court, he was arguing that the footage from the shower room was exculpatory because it would have showed Deputy Torres discovering the drugs. On appeal, he's now saying that the footage was exculpatory because it would have showed who else entered the changing stall. It would have shown when and where Deputy Torres looked into the stall, and would have resolved the core issue of the case, whether someone else left the drugs in the changing stall. And it's the state's position that there is a distinction between those two arguments, that what the defendant is arguing now is more than simply just laying out how he would have cross-examined Deputy Torres. He offered one reason for why this footage was exculpatory into the trial court, and he's offered a new reason on appeal. But regardless, the state had no duty to preserve the footage from the shower room. As an initial matter, it was not exculpatory. The footage from the shower room did not capture the inside of the stall. As a result, it would not have shown the discovery of the drugs, nor would it have shown whether somebody else left the drugs in the stall. We have no view of the stall. All we have is a view of the overall shower room. So it could have shown somebody else.
What do you mean by the overall shower room?
So the way that this room is set up is that it's a large room with, I think, 3 stalls in it, and each stall has a door and a bench. I think that they are individual shower stalls. So the shower room is a larger room that contains 3 separate shower stalls.
Okay.
And the drugs were discovered inside of one of the stalls. And the angle of the camera in the shower room shows like the larger room, but there's no view into any of the shower stalls.
Okay, but it would show who came and went to those individual stalls. Is that right?
Yes, I believe that the angle is sufficient to show who came into the stalls, but it wouldn't have shown how the drugs got onto the bench and how they got there.
It didn't show what was in the stall, but it showed the outside and would show people coming and going.
Yes, that's correct.
Okay, all right, thank you.
And so it might have shown when and where the Deputy Torres looked into the stall, but Deputy Torres testified about these facts at trial, and the defendant was able to cross-examine him and challenge his testimony and his credibility. And the state's only required to preserve evidence that might be expected to play a significant role in a suspect's defense. So according to the defendant, the state had to anticipate that 2 hours of video showing uninvolved people walking in through the shower room would play a significant role in the defendant's defense. This is unreasonable because the mere possibility of exculpatory content doesn't mean that the state failed in its general duty to preserve evidence under Ferguson, not to mention the fact that the defendant waited until November 2019, which was 3 years after his arrest and a mere 3 months before trial, to request this video. Further, the state didn't have a duty to preserve the footage because the defendant was able to obtain comparable evidence by other reasonably available means. So as we've established, the video footage would have shown who entered the shower room and the stall before the defendant, but presumably the intake logs from the detention facility would have done the same and would have provided their names. It would have identified everybody who was booked in the 2 hours before the defendant, and everybody who was booked would have gone in to change clothing. So the defendant would have been able to obtain this information captured on the footage through another means. Finally, even if the state did have a duty to preserve the footage, the defendant's not entitled to relief. First, nothing indicates that the state destroyed the footage maliciously or with the intent to disadvantage the defendant. I mean, the footage was simply overwritten before the defendant submitted his request. And as I've mentioned, he waited a significant period of time before asking for this footage. Second, the footage was insignificant. Deputy Torres provided the proof of the defendant's possession with his testimony. The footage would not have shown how the bag of drugs came to be pressed up next to the defendant's clothing after he took his street clothes off. And the defendant established that he was subjected to several pat downs before he went into the changing stall. And this highlighted for the jury his claim that law enforcement would have found the Crown Royal bag had it been on his person, and thus somebody else would have left the bag in the stall. Even if the state did commit a Ferguson violation by failing to preserve this footage, the dismissal was not the appropriate remedy because the defendant was still able to receive a fundamentally fair trial without the footage. And the defendant, therefore, is not entitled to relief. If there are no further questions, the state asks this court to affirm the judgment.
Thank you. Rebuttal, Mr. Head.
Thank you, Your Honor. If the court please, I rise just to make one point, and that is that the intake logs are ill-suited to equivalent evidence. And that is because the intake logs will tell us who came into the facility, but not which of the 3 booths those people were taken to. And in the absence of any way to demonstrate where the people went, the access to cross-examine Deputy Torres about things that happened so long ago that he has no real memory of is not actually an opportunity to cross-examine. And that's why the video is so important. Thank you, Your Honors.
Thank you. Appreciate your arguments. I believe that concludes our docket.
Yes, Your Honor, this honorable court is now adjourned.
Thank you.
Good to see all of you.